Welcome, everyone, and thank you for joining us today for the ACEDS webinar sponsored by Relativity. As generative AI continues to transform the legal industry, one question that keeps coming up is how do we trust it? So whether you're managing e-discovery matters with strict validation requirements or running time-sensitive investigations where speed is critical, building confidence in AI-powered workflows has become essential. Today's session brings together leading voices from law firms, government and legal technology to explore the foundational principles for validating AI, the strategic approaches organisations are taking to balance innovation with accountability, and what the future holds for AI in legal practice. Over the next hour, we'll dig into practical insights, real-world examples, and the questions that matter most as we navigate this transformative era together. We'll end with Q&A, so please put all of your questions either in the chat or use the Q&A function. I will hand over to the panelists to introduce themselves before we dive in, so please take it away. Jules, we'll start with you.
Thank you. I'm Jules Lambert from Deloitte in the Discovery and Data Management team. Been in the game a long time. I won't say exactly how many years, but you can probably tell by the colour of my hair. Yeah, like everybody, having pretty much daily conversations with clients about notions of trust now when it comes to Gen AI, and rightly so. Thank you.
Emma?
I'll go next. Yeah, sure. Emma Young. My day job is looking after the in-house e-discovery function at DLA Piper's Asia Pacific offices. I also am a certified ACEDS expert, relativity expert. Got my Relativity AI certification last year, but a bit like you, Jules, daily. We were lucky at DLA Piper, we were lucky enough to be part of the advanced access programs for both AIR for Review, AIR for Case Strategy, and AI Assist at the moment. So, we're definitely quickly running up the learning curve as we all are in testing AI, knowing what it does well, what to manage clients, and sort of how to move forward in the world of AI safely and with the trust of our clients.
Great. Nikki?
Hey, good morning, everyone. I'm Nikki Roberts, and I lead the APAC Customer Success team at Relativity. I've been with Relativity for about 3 years and in this industry for the better part of 20. And as Jules and Emma both said, having conversations with partners and customers on the daily about AI. Obviously, everybody that knows Relativity knows that we are obsessed with AI. So I'm really excited about it. So yeah, really happy to be a part of this panel.
Fantastic. And I'm Gulsen Dimrell, your moderator for the day. I have also been in the industry for some time, so most of you are colleagues. We've worked together at some point. I've been with Relativity now for 5 years, and I serve on the ACEDS board. So today I get to play 2 roles, and if it all fails, I can switch to comedy, but we'll see how that goes. Hopefully no need for that. So let's get started. Topic number 1, we said it's all about trust. So what does trust in AI actually mean for legal professionals, and how do you establish it in your organization? Emma, I'm going to start with you on that one.
Yeah, trust, right? It's a big word.
Yeah.
I have, pretty big trust issues when it comes to all things tech, and I like to make sure things are right, they work. But the key is knowing who's asking. Trust means different things to different people, right? So if I'm talking to, an external client, maybe I'm talking with information security, maybe I'm talking with a GC, I need to establish whether or not they're talking about, data security, data privacy. Is my client, is my data, my IP, going to be used to train a large language model? What vetting have you done on the technology to ensure my data doesn't become private, to ensure that the LLMs aren't, learning from my information? So the tech conversations are still happening, and they're super important. Knowledge about where your data travels, goes. Geographic residency is actually something that I talk about quite a lot, making sure, my data is safe. But if I'm talking to a lawyer or someone who's trying to drive the tech, I'm typically talking about, does it work? How accurate is the tool? And I think in terms of accuracy, we're going to talk about sort of validating accuracy later, but I think what does it mean to the typical lawyer and the typical client is, making sure I don't make a big mistake by using tech that I can't address, making sure that I'm using it for the right things, making sure it does what it says on the tin. So being honest, talking about case studies, talking about what's worked well and what not to do, I think is really important depending on who you're talking to. Happy to answer all sorts of questions about this later.
Great. Jules, what does it mean for you?
Well, I think of it in two layers. I mean, at the sort of very high macro level, it's I think of lawyers and trust in AI in terms of can I trust this thing with my career, my reputation, my relationship with my client, my future in the profession? It really is that frightening, understandably for many lawyers who are actively curious but often hesitant. And then a level below that, it's really, can I have confidence? Can I trust that these AI-driven processes and outputs are reliable, explainable, compliant with ethical and legal standards? So that's really comes down to establishing and maintaining trust in transparency, validation, as Emma said, ensuring that can I trust the robust governance structures? Are they in place? What about training and awareness? How can I trust my staff who are also involved in my matters to responsibly use AI and be able to trust it? How is it being controlled and monitored? And how is it aligned ethically with both professional codes of conduct and broader societal expectations around fairness, privacy, and non-discrimination? So there's quite a huge number of things, and I've not ever seen this be so sort of existentially frightening for some lawyers in the conversations I've had with them in the last couple of years.
Yeah. So I guess just to sum that up, it feels like stating the obvious. Trust equals confidence in the AI outputs, that they're reliable, explainable, auditable, and compliant with ethical standards, privilege and confidentiality, and the duty to the court. So I think that's a little wrapper around that one. How do validation requirements differ between e-discovery, so duty to the court, and investigations where you're trying to get to the truth quickly? Emma, did you want to start us off with this one as well?
I'll take this one as well. So, my humble opinion is that it shouldn't really matter. There might be slight nuances, but validation to me means, did it do the job and did it do the job well? How does it differ between a court obligation and an investigation? Obviously, in a court-based discovery, you might be needing to write an affidavit on, your process, your workflow. This is how the Pirro decision and ultimately the McConnell-Dowell decisions all made, is because a methodology was written about how a technology was used in the first instance. That was put on affidavit. That affidavit was referenced in judgment. So, there is that judiciary visibility, scrutiny, power, external communication that can and will happen in potentially litigation. That doesn't necessarily happen in an internal investigation, let's just say, but the obligation to get it right is super important. I think, Jules, I think you can talk about, some sort of, deeper commercial takes in terms of investigations, but, I don't think it should differ. What do you think, Jules?
No, that's my starting proposition too, Emma, and certainly that of our clients when it comes to investigations versus e-discovery. Accuracy, reliability, trust carries the same weight. When it comes to investigations, I suppose the distinction is that the priority shifts often to, particularly if we're trying to get early case insights and do an early assessment, it shifts to speed and actionable insight, as opposed to sort of generating a concrete asset or output like a discovery list. Obviously, discovery lists, there are methodologies in place and practice notes and validation will involve large-scale sampling and statistical validation and court-approved protocols. But investigations is, whilst accuracy remains super important, organisations may accept in early days anyway, a higher level of uncertainty or risk in exchange for speed, provided the findings are caveated appropriately and everybody is aware that we're going for speed here, not accuracy early days, because we want to make sure that we're on the right track. We want to ensure we're eliminating the right things early days and just, as I say, going for that efficiency. So there's a slightly higher acceptance of calibrated risk for faster insight in the investigations world. But when it comes to the crunch investigations, we're still expecting, when we get in the court arena in particular, we're expecting the same degree of accuracy, diligence, and reliability from the evidence, verbal testimony or otherwise. So the same standards apply, but I do think the distinction is around the early stages of investigations where we're going for actionable insight early.
I think, Jules, if
Yeah,
a
when we
practitioner
spoke,
client, I was just going to say, also, like they lead into each other. So if you have an investigation, you
yeah.
derive a result using AI, you want to bring a claim or bring a litigation as a result of the information that you found through the fast initial insights. You're going to be back at square one in any event. You're going to be testing that you haven't missed anything, through validation.
That's right. Yep.
Yeah, and when we spoke about this earlier, we talked about e-discovery. It is a little bit more rigorous, and because you need to be able to repeat it, and you need to have defensible protocols in place. And Jules, I have notes from you here from you said validation for investigations, validation still matters, but there's greater tolerance for uncertainty in exchange for the speed. So I thought that was a nice way to distinguish between the two. So thank you for that. Moving on to practical examples. So, and Nikki, I'll have you chime in here as well, but we'll start with Jules, maybe with this one. Can you share a practical example of how you've built confidence in AI outputs within your team and with your clients?
Yeah, sure. Well, you've got to work really hard. And it reminds me of the sort of even going back to dare I say, the 90s when we had to work really hard to convince lawyers and their clients, be they solicitors or barristers, by the way, when I say lawyers, and judges, that technology could reliably expedite and accurately meet the expectations of the court. Thinking the discovery side of things here in particular, really it's no different. We should be working our butts off to do things like eat the complexity of how difficult it is to put into layperson's terms what are very new to a lot of us, and certainly to our clients, concepts, workflows, and a whole raft of considerations about, which geo you need your LLMs in, for example, and in order to ensure you're meeting your data sovereignty requirements. I mean, as I'm sure that the people who are dialed in now know, this is multi-dimensional. It takes a lot of work and a lot of decoding, inverted commas, of technological concepts to get clients to the point where they're going to trust that what they're giving you isn't going to be going offshore, and if it is, that it's going to be handled appropriately, and that they can rely upon this thing that they're paying for. Because not only do they have to understand it, but their clients have to understand it as well. So it's a difficult challenge, and the way we've gone about it, multifaceted, but one is to work really hard on articulating in terms that our clients can understand how this thing works, this black box of Gen AI, what's involved, so that they can so they're at least somewhat fluent in it, because their clients are asking them the difficult questions and they need to be able to answer them too. So that's one part of it, is working really hard to ensure that people understand how the security dimensions of this thing work. And the second is to then show them some stuff and acclimatize them to the actual tools, which we've done through proofs of concept. And these proofs of concepts, and we've done a lot of them in the last couple of years. They're really quick turnaround. They're short and sweet, often 2 weeks, 3 weeks, and we maintain very regular contact with our clients throughout that couple of weeks to ensure that they're in the loop as to validation points and can validate outputs themselves, use the platform, and ultimately are convinced of the value proposition that we're espousing, that this thing works, it's trustworthy, and it's better than what you're currently doing now. So proofs of concepts, and as I say, articulating how the damn thing works, and then using some other assets like prompt cards as an auditing tool, which down the track I think will be appended to affidavits of documents and the like to demonstrate to all and sundry that the right processes have been followed, they're auditable, and can be trusted. So there's quite a bit to it, and this is why
Yeah.
we're still in proof of concept world, I think, a lot of the time. And we do have a solid, I was going through it yesterday, maybe 8 to 10 live fire use cases across a variety of client industries, corporate, corporate in-house, law firm, and government. But we're still very much in proof of concept land and tell me how this works land. So yeah, that's a
Yeah.
long-winded answer of saying we need to do the heavy lifting, and we need to chaperone our clients very carefully and responsibly rather than rushing them along through proofs of concepts and similar activities. Coulson?
Yeah. And you'd mentioned putting clients in the driver's seat and having clients validate outputs themselves. So using auditable
Mm,
prompt cards as artifacts and that you can
mm,
revisit later. And
yep.
and Emma, you had mentioned similar things. So we'll move to you, the side-by-side comparisons that you spoke of.
Yeah, so as I said, we've run a number of AI matters, including F for review. I'm going to give you a practical example of what we do, what we've done in the past, and I did another one yesterday with a lawyer partner client that hasn't used, Air for review before. So, a lot of this is in the relativity material, but in terms of building trust, a practical example of getting the clients on board with the use of AI, it doesn't cost very much money to take a sample of documents, and it can be, like 15 relevant documents, 5 not relevant. The numbers are a funny thing, how many documents you choose to sample, but I'll get to the upfront cost of doing all of this in a moment. But in any large scale document review, a senior lawyer is going to have to be drafting some, notes on review, like a review brief or review protocol, whatever you want to call it. But ultimately, that's the stuff used to draft the prompt. Yesterday, I imported into the, Air for Review prompt engine, the AI prompt engine, the discovery categories. I put that in, then I exported out the template and gave that to the senior lawyer and said, look, this is a first draft, fill in the blanks. The job is he then picks documents to test, and it costs sense to run a draft prompt against a universe of documents and actually sit down and show them the results. I've done this on a previous matter where they didn't want to use relativity, but I exported it out to a spreadsheet, and then you export the rationale considerations and the citations against the example documents with the human review. You put it in front of a lawyer and say, well, this is what AI did. Typically, the feedback is, wow, great, I can see what it's doing. Typically, the feedback is that compared with a paralegal who's making a relevant, not relevant decision gives you so much more transparency. And transparency is something that you've been touching on, Jules, is you actually see what the technology is doing. I've had examples, though, where AIR was too inclusive. So, there was a matter where a lot of the marketing and sales collateral that was in the universe, that was keyword responsive, was not of interest, was not within the discovery categories, but it was being tagged as relevant, and we could understand why. So we had to draft into the prompt, and marketing material and sales collateral will not be considered relevant. We then reran the prompt and we could see the change. We actually go so far as like in the spreadsheet, like highlighting green the decisions they agree with, like orange the ones that are maybe borderline. And red the ones that we want to see change later, so that when we run it, and then this is where, like, as e-discovery professionals and as ASEDS experts, you can really come into play here, is if you do a lot of that just heavy lifting for the lawyers and chuck it in front of them in a way that's really quick, stoplight system, easy for them to see, you're making their thought process so much easier. You're, removing that sort of barrier to entry. Oh, it's a new technology. Oh, it's a new interface. Oh, I have to do what with a dashboard? Look, I'm not necessarily teaching them. I will some, but I'm just laying it out on the table. That way, even they can sort of go into a meeting room with a partner and say, look at these results. Are you comfortable? And I think that's been my approach so far. So, Jules, you'll call it a pilot or a proof of concept. And I think just giving them the visibility and showing them exactly what the AI is doing is a really great way to give it a go.
I love
That's
it.
what we've been doing.
And Emma, your choice of words there, where you chuck it in front of them and just you're very firm about them seeing it and getting them comfortable. That's one way to do it. So it's really answering the question, getting them to understand the why behind it. And if they can see what the technology is doing and they get more comfortable with it, then they feel that they can defend it. They're going to be using it. So Nikki, I think this is where I can come to you with the customer stories and your interactions with the customers, where you're having these conversations and building that confidence. What are you hearing?
Yeah, Gulson. And look, before I jump in, I just want to echo what both Jules and Emma said regarding, POCs, samples, testing, and transparency. I think, when I jump in to discuss a customer success story that we've had, in this area, all three of those things are kind of, very largely hit upon here. So a really good example of showing how this confidence was built by one of our customers, especially in the APAC market, was the Quadramenta case study, which I'm sure many of you have seen or heard of. In this matter, Quadramenta had critical deadline and very large document set as well. Accuracy and defensibility were non-negotiables. And so the approach they took was, rather than rolling F review out across the entire data set immediately, they started by running F review on a defined subset of documents. So that sample set that Emma was discussing. They then validated the outputs through the sampling. They compared them, the F review's decision with the human reviewers' decisions that had previously been coded. And then after that, they scaled once they were happy with the results. What really kind of built that confidence was, kind of circling back to what Emma said earlier, was this transparency part. So the senior reviewers could see what FR review's reasonings were through the rationales and citations, so how it got to that reasoning. And then they assessed whether the relevance was being interpreted in the way that they expected it, which made it easier for them to refine the prompts when needed, and to explain and defend the process as well. So once the confidence were established, they were able to quickly scale and then significantly reducing their review time and costs. I mean, I think in the end, they saved over 25 days of review, and reducing that total cost by 85% as well. So the benefits were there, once they were confident with the process, the outputs, and those results really in general. We're
Thank you.
seeing,
Can I
we're
just
coming
add,
to,
just sorry, a bit of a footnote there, and um, back to Emma's point too about unpacking things and demystifying, bringing them into the fine detail. And one of the things that has also worked really well for us is to not start with the tech light show, the software demo, but to actually start with the boring but important. Number one, here's the legal framework. So core practice notes around the use of AI, which almost every jurisdiction now has. So setting the scene that way, like, oh, okay, so the courts are actually giving it their blessing to at least some of this. So we unpack that a little bit, and then let's look at how we build a prompt. So we're actually holding off the light show until we get some of these real foundational ideas into their heads, because prompt skills are really they underpin a hell of a lot of this. You can have the best technology, but if your prompt's no good, then you've only got half the job done. So, and drawing analogies between writing a good prompt and instructing in a memorandum form, and we actually do a side-by-side comparison, um, a paralegal or a first-year lawyer. And really, they're very, very similar in essence. And so lawyers seem to go, aha, at that. And then we move them on to, okay, so now let's talk about AI into Gen AI over the last 50 years, that it's actually not new. It's been around a long time. Here's the evolution. We're now looking at agents and agentic AI, etc. And then now we're going to show you how it's actually worked in recent times. And that sort of narrative, building that narrative that way, ain't a bad way to go, and it seems to work.
Yeah, and
Jules,
Jules,
it's like you know what's coming up next because that's exactly where I wanted to take the conversation is the frameworks. Sorry, Emma, were you
No,
about to chime in? No?
agreed, love it.
So let's unpack that a little bit more. Jules, you're right on topic. So frameworks, what frameworks or processes have you got in place to ensure accountability while still moving quickly with AI innovation?
Yep. Thanks. So yeah, we defer to the practice notes, or at least we refer to the practice notes, as I said, as sort of, hey, there is something outside of us. There is another entity outside of us saying that this is a good idea to use. So read the practice notes, and communicates your intent to use AI to the court and your opponent. Then some essential safeguards, um, you know, um, around maintaining robust human in the loop review. We're all sick of hearing human in the loop, but it's true, especially for relevance and privilege calls. Conduct some defensibility checks, um, document model performance, validation statistics, and error analysis, back to sort of these ideas about documenting things and having some assets that you can go back to. I've already said be transparent with the opposing counsel in the court about your AI methodologies and your intent. Validate outputs with statistically relevant sampling and third party review if necessary, and make sure that efficiency gains are embraced, but not at the expense of accuracy, transparency, or legal defensibility.
Yep. So really borrowing the disciplines from traditional e-discovery and then applying them to Gen AI here.
Yeah,
And the human in the loop matters, and we'll talk a little bit more about that because it's the human in the loop that has the obligations to the court, so
yeah.
and held accountable. Emma, I'll move to you with a different question. So for e-discovery matters, how do you balance the efficiency gains of AI with your duty to the court, and what safeguards are essential?
Yeah, so I think efficiency and safeguards due to the court, due to the client, like underpin sort of all of this. I think in particular, one thing that I've seen, clients, lawyers, the community concerned about is, based on the Harman rule. So, I don't know, for the non-lawyers in the room, the Harman rules are pretty international, but, apply specifically to Australian civil procedure. So the rules that govern all court practice, which basically says, it's an implied undertaking that if you receive information through court process, so through discovery, through expert evidence, etc., the receiving party must not, for any purpose other than the conduct of the proceeding, use that material. So unless the court gives express permission. And before AI, this existed. This is not a new rule. It just means that if you go into litigation with someone and you find out a stack of information, you receive discovery, you can't then take that discovery and use it for commercial gains or use it for some other purpose. That's the safety and security of court-based discovery and confidentiality. And I think what happens with generative AI is everyone understands that these large language models are learning, from Reddit, from the internet, from, all publicly available sources. So it's really important. And I think that's why I sort of started with who are you talking to? Because the underpinning framework for, use of AI by a client for court, for commercial, litigation processes, is that information security, is making sure that that knowledge that's being learnt and used and trained, your prompt iteration decisions aren't being used then back to the algorithm, to the large language model, and then being used on a case. And so, Relativity's got that sorted through the framework, but I think that is something that maybe e-discovery professionals don't understand the background to that. There's probably plenty of lawyers in the room who are like, yeah. So that's important. And then obviously we go back to, we step back in time to, the fear that was active learning, predictive coding, technology assisted review, whatever on earth you used to call it back in the day, and how, we talked this talk back then, we've walked this walk. It's kind of boring, but, oh my gosh, the big black blocks, machine learning, how can I trust that it's accurate? Should I be using this technology? But I think, Jules, you hit on this. We did a Air for Review project. I think it's just because the number sticks in my head. It was 27,000 documents reviewed in 8 hours, right, by AI. That's the start. I think Relativity told me it was going to take 12 hours, like the little button, but it actually finished in 8. So it finished 4 hours ahead of schedule. It's a huge amount of document review to do at the click of a button, but obviously you go so fast, unlike human review, you don't really have a chance to, when you've got paralegals in a room, they're reviewing it however many documents an hour, you can go behind them and check what they're doing, you can QC and keep up with them. But when, you're doing 27,000 documents in a couple of hours, the upfront accuracy of your prompt, all of that sort of upfront cost is really important. So I think it does put a huge focus on validation. But the thing is, validation is just the same for sort of AI review versus active learning. We got there with active learning. At the moment, what we're doing is we're putting eyes on human review for all the relevant documents and the borderline documents. There is efficiency in terms of using the AI, but at the same time, if you have not trained the model well enough, or if you've not written the prompt well enough, you could potentially have too many borderline documents or too many relevant documents that are getting overturned. So if you've got human eyes on all of those, it's actually potentially being inefficient and costing a lot. But obviously, then you've got the validation on the other end. We call it we call it the discard pile. I don't know. It's just language that's somehow stuck internally. The stuff that you're not looking at. Doing the standard validation, statistical sampling that we did for active learning is the idea. I wonder, if we will get to a world in which we may not be looking at all of the relevant documents or all the borderline documents, or on truly large scale litigation, what that might look like in the future. But yeah, I think that's sort of what we're trying to do, is really good prompts up front, that prompt iteration to make sure you don't have too many relevant documents, and then the validation on the back end to make sure you haven't missed any relevant documents. But it's pretty the same.
Yeah.
Right.
Nikki, I feel like there's an opportunity here to plug all the different things we do call this over the years. And so I guess, Air for Review is one of those areas that has iterated and moved very quickly and evolves. And a part of your job is to make sure that customers are aware. And so did you want to speak a little bit about that and that integration, Air for Review being integrated with Review Center, which used to be called Active Learning, but I'll pass it to you to answer that.
Yeah, thanks, Wilson. Definitely. And Emma, one of the things that you just mentioned there was that prompt iteration. And one of the big enhancements that we made to Air for Review was that prompt Kickstarter. So that's the engine that we have where you can upload 5 documents, and their Air for Review will then run those documents and be able to get what it thinks is the best prompt for your data set. Have you had a chance to use that yet? I'm just wondering how your experience has been with that when it kind of comes to that prompt creation.
Yeah, so we've used it a few times. So once I put a statement of claim in, it was an issues-based review, and the statement of claim informed the discovery, and we were using it on incoming discovery, and it did quite a good job. This was before the issues-based sort of detail was being filled out. So I got the issue headers, but we sort of had to put a bit more work into sort of sub-training on those issues. Yesterday, I just did it for the discovery categories that I was mentioning. And, people and aliases was great. Acronyms was amazing. It was like insurance-ish related. So it was talking about various insurance acronyms. That was great. Noteworthy organizations, because it was the discovery category. So it was a court order and it had the parties at the top. So it actually had, like applicant, respondent, it pulled all of that stuff out exceptionally well. It's good because it does a little heavy lifting, which is really important in sort of removing that barrier to entry. I will say my only piece of feedback is it's a little American. You have to read the 5 document types and translate that into Australian. I will say that for this audience, but yeah, it's pretty good.
I'm glad to hear it. Yeah, I've heard, from a lot of customers, it is hard. Look, prompt writing is a skill within itself, So people do need to be educated on prompt writing, and what, the most successful prompt would look like depending on your review. So that prompt Kickstarter, I've heard fantastic feedback because right now we're still in that, that learning stage, that education around, you know, getting people onboarded and also getting them to understand how best to prompt for your review. So I'm really glad to hear that you've used it, and that gave you good results. Yeah, that's what I'm kind of hearing, Gulson, throughout the market as well. That prompt Kickstarter has been really successful in an aid for reviewers.
Wonderful. Jules, I'm going to move to you with the next question, because, we are talking about getting results quickly, moving quickly, everything's just quick and urgent. So when we talk about investigations, how does that sense of urgency to get to the truth quickly change your approach to AI validation and the risk tolerance?
Well, it's probably quite similar to what I said earlier about, in an investigation, it's speed to insight. And so there's an inherent tension there, obviously, with that. People want to get results, but they also need to get there in the right way. So validation, realistically, is early days, and I can't emphasize this enough that it's the early. I think the further you go down the track, the more you want to be sort of tightening up on your governance, and your validation processes. But early days validation is often lighter touch. So the emphasis again is on rapid feedback and iterative model improvement. So we everybody wants to get cracking and they want to get traction early. They want persons of interest and the key events to be sort of coming into sharper focus. So therefore, in at least what I've seen is organisations may accept a higher false positive rate initially, provided the material findings are prioritised again for human review. So in that sense, the same principles of human intervention and human in the loop apply. But the risk appetite's going to be sort of aligned with the investigation stakes. If it's high stakes, you don't see people mucking around early days as far as making too many compromises on the validation and the overall approach to the investigation. And we've certainly been privy to many that fit that category where the stakes are high, and there's got to be clear communication of the limitations and the caveats to clients and stakeholders, as to the outputs, particularly if the
Yeah.
pressure's on, as it invariably is, to start to pump out some results and, in brackets, maybe inverted commas, insights. So this sort of fit for purpose validation approach is essential to respond effectively when it's an urgent and evolving investigation.
Yep. Yeah, you mentioned proportionality, and so that's really the summary of that.
Yep.
Fit for
Yep.
purpose, what's at
Exactly.
stake, the importance of, you mentioned having those day one conversations with the client, so very early on getting involved about the limitations, the caveats, and the risk appetite. So
It also goes back to something that I was chatting to somebody about this week. It was a bit of a high level discussion about, our role as advisors, if you like, or consultants to the legal profession, and something that you sort of arrive at later in your career, which is the confidence to push back. And the confidence to push back comes with experience and your own hard-won insight as to why people should not rush to conclusions. But um, it also requires you to have a good command of the subject matter, in this case, Gen AI, so that you can explain why people should not be rushing to conclusions and sometimes need to slow down in order to go fast. So that's one thing I would say to certainly the people I coach in my organization is, don't be afraid to push back, but make sure you can back it up with something. If you're resisting what you see is the wrong way, maybe put yourself in the firing line, but do it in an informed way.
Cool. So we started with trust. We've talked about innovation and accountability and moving forward quickly. So looking forward, we want to talk about the future of AI. So now I'm going to have to ask you to, look into the eight ball and just see, and Emma, I'll ask you first, where do you see AI validation heading in the next 12 to 24 months? What will become standard practice? Thoughts on that?
Yeah, well, watch this space. What the conversation that I've had sort of on repeat is that right now we're at this slight, you take, two steps forward and one step back. We've just taken a little step back in terms of ease of barrier to entry onboarding with a lot of this Gen AI stuff. So if you recall the very early stages of TAR, the best practice was, get a senior lawyer to train the system on however X many documents before, the decisions were, the lower ranking decisions or before the 50-50 TAR ranking documents were spread over the universe. I'm talking like the very early iterations of where you got a binary relevant, not relevant decision, not so much this continuous active learning. And that was hard because it required a lot of upfront training and effort. And then we sort of got to the stage where now we just use continuous active learning. Yeah, the lawyers have got to train the, paralegals or brief, whoever, a junior lawyer around what to review, but it sort of seemed a little bit easier. Now we're sort of stepping back a little bit and saying, for all the good reasons that we've talked about, including commercial ones at the moment, to do with like the pricing model and, time and risk and whatever else. We need a senior lawyer to, draft the prompt and, test the prompt. And I think what I'd like to see, and I think where we're going, and Nikki, you talked about this quite a lot, is that prompt Kickstarter takes away a little bit of that sort of heavy lifting. It's, that AI is doing a little bit more of that onboarding for myself. But so I'm interested to see where that goes and how far that can go. And we'll talk a little bit about human oversight, but I still think, a subject matter expert is really key. But I think, let's see how far, this prompt Kickstarter stuff can really help. But also, in terms of validation, one of the concerns that I suppose I have or see is that subject matter expert who is drafting the prompt comes at it with his litigation theory, or, the litigation hypothesis, right? So they're coming at this from their perspective, show me documents that say X or Y, and yeah, they have to take into account, discovery categories or potentially documents that are negatively impacting their case as well. But I do always wonder, what don't they know? What's in the data universe that they have no idea about? This always comes up when we use AFK strategy, say, for example, where I get a stack of, highly relevant documents that I want to put into a chronology, and all of a sudden I've got like 100 documents that didn't generate a fact. And the reason is, when you look at it, is because they have nothing to do with the prompt. They've given them to us, but it's like, well, that's got nothing to do with what you told the system was of interest. And so that's just the truth of the real world. And so I'd like to see where things like error assist or, being able to, run the GPT model against a universe of documents and say things like, and tell me what I don't know. Tell me if there's anything in there that I haven't addressed that I might be interested in. And I think potentially there are sort of more sophisticated litigation tools out there that are a little more advanced in that space. But yeah, I'm really keen to see, the future, to make sure that any, skeletons in the closet are unearthed, early case assessment, et cetera, et cetera. So I'm really keen to see where that goes.
Yeah. And
Anyone
Jules,
else?
Um,
anticipated trends.
I'm nodding and smiling at that last point you made, Em. I think it's a brilliant point about what's missing, because we're often, we've got a corpus of documents, we're asking questions, we're interrogating the data, we're writing prompts for it. But then sometimes, and we had an example this week, the question was about what's not there. And so, the chat function talking to your corpus of documents and asking it what is not there is super important. But anyway, the validation. So I think of validation, I'm sort of zooming out a bit here, so bear with me, but I think a lot about, probably because I'm getting older and have been around lawyers for a long time, but I think a lot about reflecting on what makes a competent lawyer these days compared with when I started a long time ago, and how the notions of or what constitutes a competent lawyer has evolved over the years. And I think two of the things that, in my mind, um, uh, help define competence among litigation lawyers in the disputes world is their comprehension and their ability to comprehend and apply Gen AI principles and technology to a case at hand. Um, so where I see that going is, and where I'd like it to go, is a little more in the US and some European jurisdictions direction, which is actually baking that into codes of conduct and rules of practice around, what is defined as competence. In my mind, if I'm paying for legal services, and many of us have and will, um, like my mechanic, I want them to be right up to speed on the latest practices and technology that they're bringing to my job. And anyone that doesn't may be overlooked. And I think we're going to see that down the track. And that's where I see AI validation heading, to bring it back to this question, maybe in too many years from now down the track. But what I hope will become standard practice is that if you can't write a good prompt as a litigator, and apply a trustworthy validation process, then you're outside, I think, of what can be described as a competent lawyer. So that's where I see AI validation heading, and what I think will be standard practice is all of these things being deemed essential in order for a lawyer to be seen as competent beyond having a practicing certificate.
Yeah, yeah. And you also mentioned shifting of or moving validation to automated monitoring. So that's another futuristic
Yeah, yeah,
output that could happen.
yep.
Okay, so let's talk about the human in the loop. How will human oversight evolve? So I'll start with you, Emma. How do you see the role of human oversight evolving as AI systems become more sophisticated?
Yeah, sure. Like I said before, I do feel that there's a sense of sort of upfront, we could switch on a Cal project in the background and let it run. We used to talk about that being an option, to lower the barrier to entry. We don't have that with, these AI tools, because you actually do need that subject matter expert. But I think to sort of put that in a way that maybe lawyers can understand is, there's a really big difference between giving a room of, let's say you have 20 document reviewers, you give them the pleadings, the discovery categories, a couple of memos, brief to counsel, and say, go in a room and read this, and now go and do my document review. You know that the output's just got to be nowhere near as good as that same team being given the same set of documents, but then a senior lawyer or a partner sitting in the room and say, this is why, this is the background to the case, this is how the litigation was brought. Like, here are the commercial nuances, here's, what my client's trying to do. Here's what I might expect from the other side, just giving that really nuanced take on the case gives, that level of nuance, extra thinking that you don't necessarily just get with those sort of binary 1-0 sort of computer-based approach. So I think that human in the loop part just will never go away. But also, I think to talk to people who are afraid that AI might take their jobs, there's still a huge area for human validation, eyes on documents. This is the thing that I've been teaching lately, is like there's so much that AI still can't do and AI doesn't replace. So someone was trying to use Harvey the other day to do a keyword search and they were wondering why it wasn't working. And the answer is because it's the point, right? It's a large language model. It looks at things like that. It doesn't objectively look one and two. And even Harvey, Harvey has this verbatim block that says, I've taken this verbatim, but the question was, who was this email sent from? And then it said verbatim, but it was from the email signature, but that actually sent it from a personal email address. So it's like, although it was like, Nikki Roberts at Relativity, you'd sent it from Gmail. So it's like, well, this is why like there's still human consideration in what do you want the output to be. That's not going to go away in a hurry. And yeah, so just that expertise around data and technology, I think is really important for the e-discovery community here. Just because these tech tools don't exist, we are experts in, the difference between human behavior on a data set and what keywords, false positive keywords, human behavior, deduplication, like email threading, getting an identifier on a document so that you can be objectively clear what document's being talked about, as opposed to the email from Emma to Jules dated the 26th of February at 11 a.m. There's just so many things that we do as e-discovery experts that are critical to driving these technologies well and correctly. Yeah, so don't underestimate the power of your
Yeah,
knowledge and experience.
and Jules, you'd mentioned the same thing. It's rebalancing toward human-centered AI, I think you mentioned, and we're
Yep.
experts. You're the experts that interpret, contextualize, and explain the AI outputs. Did you want to
Yeah. I mean,
add anything else to that?
yeah. Just a brief comment. I mean, we will remain the ultimate arbiters, particularly where legal, ethical, or reputational stakes are high. Any lawyer will tell you that right now, and any lawyer that values their practicing certificate will tell you that. So, yeah, to Emma's point, people aren't people aren't going to be replaced by robot lawyers. Hopefully not in my lifetime, but I just have difficulty seeing it happening because it's such a human enterprise, the law, the application of the law. We're
Yeah.
solving human problems ultimately, not abstract sort of things that Gen AI came up with. These are real life situations, and people's lives and reputations and um, uh, their wealth base, etc., are at stake. Their livelihoods are at stake.
Yeah.
So yeah, people want to be looked after by people.
Yeah. Alrighty. We're coming to the end. We're running hot on time, so please, if you've got questions, either use the chat or the Q&A function. Last question for everyone, and I'll stay with you, Jules. Advice for organizations starting their AI journey.
Yeah, well,
What
look,
advice would you
as
give?
everyone knows, I'm sure on this call, there's no shortage of advice, which is a great thing and also a real pain in the neck. But I've sort of landed on, like any good consulting firm worth its salt, where I am, Deloitte, we've got our own trustworthy AI framework, and I've read it and I've chatted to the people that have helped develop it here, and I think it's actually pretty good. Yes, I'm biased, but hey, it's got 7 key dimensions, and I'll just sort of reel them off quickly. Just you'll recognize them. Safe and secure, um, robust and reliable, accountable. So these are the dimensions that need to be synthesized in order to build trustworthy ethical AI. Plus, it's got to be responsible. So that is the technologies created and operated in a socially responsible manner. It's got to be private. It's got to respect privacy and confidentiality in accordance with regulatory and other obligations. It's got to be transparent and explainable. We've talked a hell of a lot about that. It's got to be fair and impartial. So it's got to include some internal and external checks to help ensure equitable application across participants. And finally, the final thought is that, if you're embarking on this, you've got to go in with the mindset that this is just an enabling tool and not a replacement for professional judgment. That's principle number one.
Love that. Nikki, I'll go to you. Any advice for anyone starting off?
Yeah, Gulson. The advice that I'm constantly giving customers that are starting their AI journey with relativity is start small, start purposefully, and really don't jump in with AI trying to solve everything at once. Sample, test, validate, document. And finally, lean on us. This is what we're here for. Lean on your technology partners. Understand what the AI is actually designed to do, its limitations, how to use it responsibly, is just as important, really, as the technology itself. Work closely with us to leverage our expertise. Especially in the early stages, we offer a lot of onboardings, demo sessions for new tools. They're all great ways to get to know what the tools are, how they work, and how to use them effectively. So all of those sorts of onboardings, air shows, learning labs, they're great ways to really kind of engage with the vendors and be able to know exactly where to start. And we're really there to help you the whole way through the process. So lean on us.
Thanks, Nikki. Emma, final thoughts.
Uh, don't get too stressed about which algorithm, what, model, what technology, right? Take what you've got or take a pilot or, I think relative is really easy because it's inbuilt, right? But if you've got another technology, surely you've got Copilot, just have a go is probably my advice. And my second piece of advice is don't just write off AI technology because it didn't work for something. I think, I gave the keyword search example, the tools are meant to do a particular thing. And it's like I give the example of, just because you can do your, mathematical equations in a table in Word doesn't mean you should. And just because you can write a letter in Excel doesn't mean you should. So, doesn't mean Excel's bad, doesn't mean Word's bad. Just because you're not, the AI tool isn't doing what you think it should doesn't mean it's a bad tool. Maybe you're using it for the wrong thing. So just have a go, know what works well, and just be mindful that it isn't a magic weapon for all things. Just have a go.
Yep, wonderful. So we've got a couple of questions. We'll move to those very quickly in case people need to drop. So if you do need to drop, thank you, everybody. I'm going to go ahead and answer the first one. Someone said, I'm new to Gen AI in e-discovery. What is the first thing that I need to do? I can't help but say this is great for a plug to say you can come to Fest and see us all there and have a chat. So I'm just going to use that chance to answer that question that way. Thank you.
I'd
Thank
add,
you.
I'd add,
Love
come to ACEDS as well. I would suggest because there's a good,
Absolutely.
a really good cross section of people that bring a lot of different things to the table. So that's my little plug for ACEDS as well.
And then
Fantastic.
relativity, I got the relativity AI certification, which just gave me a little bit of understanding. But the actual study guide for the what's it called, Nikki? I'm going to call it the AI certification. What is it called?
Yes, it
That.
is. Yeah.
The study guide for that's really good because it helps actually turn your mind to some of the things you need to know as a technology expert, including that data sovereignty, data privacy, relativities, information security frameworks, and then, what are the tools? What does it do? What's a prompt? Like language. I think language is, it can be daunting as a person new to AI, like the terminology that maybe we might have thrown out here might be new to some of you, but yeah, that might help.
Yeah, sorry, Emma,
Yep.
I think the certification you're referencing was the Generative AI Pro cert that we have. Yeah, there's a plug.
Thank you. Jules, maybe you can take this next one. How can you ensure that the technology will always respect privacy and confidentiality against viruses and advanced hackers?
Um,
I'm biased to
well,
say you should use technologies like relativity so
it,
for
I
security,
mean,
but I'll let you
I'm
answer that
not
one.
a CISO or a, IT security expert by any stretch. So I just simply get uh, the subject matter experts to convince me as a compared to what they are. And, I'm the layperson in that example, and I just get them to spell it out for me in terms I can understand. And I have, as recently as this week, frustrated the hell out of a colleague because I was just not accepting his answers because I couldn't understand them. They were still some of them, and this is not a criticism because this person's brilliant at what they do. They're actually a friend, and this person lives in that world, but I made them work harder than they probably wanted to give me to give me in terms I could understand and explain to my client answers to that very question. So rely upon um, your CISO team to give you answers to those questions.
Great. Thank you. And I think we're right on time. We've gone over by a minute, so we'll end there. Thank you, everybody, for joining us today. I hope you enjoyed the session. I've enjoyed moderating it. Thank you, Jules. Thank you, Emma and Nikki, for speaking with us today. Enjoy the rest of your day, everyone.
Pleasure.
Thanks,
Thanks, everyone.
Quilty. Thanks,
Guys.
everyone. Good to
Bye.
see you. Bye.